Hello, good morning, good afternoon, good evening. Welcome to my YouTube channel. My name is Ogbanje Joseph. Please hit the subscribe button to subscribe to this channel. Like and share this video as well. Today we'll be looking at the relationship between international law and municipal law. The relationship between international law and municipal law. The relationship between international law and municipal law has been a subject of debate among scholars, among scholars. Okay, while some scholars argue that international law is superior to municipal law, others have also argued that municipal law is superior to international law. Okay, now let us look at the difference between the two. Okay, let us look at the difference between the two. What is international law? International law is the law of states. Is the law of states. It is the law that guides or regulates the activities of states in the international system. Now, it is the law that specifies the interactions of states, the intercourse between states, between and among states in the international system. So it's the law of states. Okay, so but municipal laws are laws within a particular state. So is state laws. So while international laws are laws of states, municipal laws are state laws. Okay, so constitutions that are made within a particular state, within a particular country, can be regarded as a municipal law. Okay, in international law, there are institutional frameworks that actually have been put in place to implement international laws. Or, for example, we have International Court of Justice. It handles issues that actually concern states. Okay, states, states versus individuals, or states versus multinational corporations, or state versus body or groups, okay, or in other institutions. However, okay, and then that is International Court of Justice. We also have International Criminal Court. International Criminal Court actually handles, issues of, human rights violation. Hits issues of human rights violation. We are talking about issues of genocide, issues of, war crimes, and all of that. These are institutional frameworks that have been put in place to actually address international law. But what about the frameworks or institutional frameworks put in place, to actually address municipal laws? We are talking about, we are talking about state court. We are talking about courts. The judiciary within a particular country. But in the case of Nigeria, for example, the Supreme Court is the highest court of the land that people can actually take their case to. Okay, so that is actually what it is. Now, what are the features of international law? Now, international law is adopted by states as a common rule of action by and for states. So it is actually adopted by states, okay, as a common rule of action by and for states. So it is a law that is adopted by states. It is not just one state sitting somewhere and actually formulating that law or those laws for all states. It is all the states coming together to ratify a particular treaty, charter, convention, and protocol, and all of that. Now, once that has been ratified by all states, it becomes an international law. Okay, that is number one. Number two, it is derived from customs and traditions. Okay, customs and traditions, treaties, and general principles of international dimensions. So, customs and traditions. So, what are customs and traditions, okay, within the international space? What countries have actually been used to, what countries have been doing over time. Okay, over time it becomes custom and tradition You understand? As well as it will form the general principles, general principles of international dimension. That is number two. Number three features of international law is that it governs the relationship among states. International laws are put in place to govern the relationship among states. Okay, so that is number three feature of international law. Number four is that it produces collective liability in case of violation and sanctions for erring states. So if any state actually errs an international or errs against international law, you know it produces collective liability in case of violation and sanctions for errors. So the sanction is going to be collective. Okay, the sanction is going to be collective. It's not just one state actually sanctioning one other state that refuses to obey international law. That is actually the features of international law. But what are the features of municipal laws? Okay, the features of municipal law is that it is the enactment. It is actually enacted by the law-making body of that country. For example, we have the legislature or the parliament that actually makes that law. Okay, the law must be made in conjunction, in line with the culture and tradition of a people, the way of life of a people. You cannot go and import a law that is actually not in tandem with the way the people are living. Okay, that is number one. Number two is that it governs the relationship between individuals and the states. Okay, and the state. So, municipal law governs the relationship between individuals and states. Okay, then number three, enforcement. The enforcement is undertaken by a law enforcement arm of the state. It is the law enforcement arm of the state that actually enforces municipal law. So, for example, we have police, we have the paramilitary, we have all of that. So it is actually the law enforcement within that state that enforces the municipal law. Then number four, in case of violation, the aggrieved party can seek redress within the state. So you are not going outside the state, outside your country to go and look for redress, to go and seek for redress for a municipal law. It has to be within the states. Okay, but let us come back to the relationship between them and look at certain theories that have been used to explain the relationship between international law and municipal law. The first theory that can be used or that is used to explain the relationship between municipal law and international law is monism. Monism. What is monism? Monism is actually a theory that talks about the relationship between international law and municipal law, from the perspective that, okay, both municipal law and international law draw their inspirations from a single system, which is a system of law. Ideally, therefore, there is no distinction between municipal law and international law because single legal structure binds humanity collectively or singly. What does that mean? It means that there is a single legal structure that binds humanity together. For example, what is humanly evil in one country or what is humanly unlawful in one country is actually humanly unlawful in all other countries of the world. Example is rape. Rape is actually humanly evil or unlawful in Nigeria. So it is with rape in every other country of the world. We are talking about murder. We are talking about manslaughter. We are talking about genocide. We are talking about war crimes. So all of these are actually, they are single. These are single, these are single legal structure or framework, single legal structure that binds humanity collectively, together everywhere you go. So what monism is talking about is the fact that both international law and municipal law actually draw their inspiration from one single system. So there is no distinction between the two of them. Okay, that is number one. Number two theory that talks about the relationship between municipal law and international law is dualism. Dualism. Now, this talks about the fact that municipal law and international law are products of two distinct legal systems. Thus, their character, nature, and contents, as well as context, are different. Okay, the subject of municipal law are individuals, while the subject of international laws are states. So this one is dualism, says there is no relationship between municipal law and international law. Both of them are actually separate. They are separate, because if you are talking about the subject matter of municipal law, according to this theory, is individuals, while the subject matter of international law is states. You understand? So both of them actually do not work together. They have distinct legal system, and their character, nature, context are different. Okay, so those are the things. Now, number three theory is transformational theory. This theory says that international law is consensual in nature, but municipal laws are not consensual in nature. So international law must be transformed into municipal laws before it can work. Okay, so international law is actually consensual in nature. You must actually ratify that protocol, convention, treaty before it is binding on you. But in international law, whether you ratify it or not, once it has been passed by the parliament, it is binding on you. So it is non-consensual. You understand? It is actually consensual. Okay. So before international law is actually operated within a particular jurisdiction, it has to be transformed into municipal law first before it can work. That is actually for the transformational theory. Then number four is specific adoption theory. This argues that the rules of international law cannot directly apply to the cases within domestic jurisdiction unless through specific incorporation into municipal law. The national law cannot encroach into the domain of a state except the state allows its constitutional machinery to be applied. What does that mean? It means that before an international law can be operated within a country, there must be specific adoption of that law, and it must be incorporated into the internal municipal law of that country before it can be operated. A very good example is the Child Rights Act. The Child Rights Act, has to be, incorporated into, the Constitution of Nigeria and constitutions of the states, and the laws of the states as well, before it can be operated. Okay, then number five is delegation theory. This means that international law delegates each state's constitution the power to determine the conditions under which the provisions of a treaty or convention are to come into force, and the manner in which they may be embodied into state laws. In which case there is a single mechanism of the creation of the law. What does that mean? It means that now this delegation theory is saying, okay, that the international law delegates to each state's constitution the power to determine the conditions under which the provisions of the treaty or conventions are to come into force, and the manner in which they may be embodied into the state laws. Okay, so those are the things. Now, what does that mean? It means that before an international law can actually be embedded into the municipal law, then these powers must be delegated to it by the international law. Otherwise, the municipal law cannot actually, cannot be incorporated. Otherwise, it cannot be incorporated into the municipal law and operated within the state. Thank you very much.